Good afternoon, and welcome back to our first session of the afternoon, which will be voting rights issues for adults under guardianship. Our presenter this afternoon is Mitchell Hagopian. He is a managing attorney with Disability Rights Wisconsin, Wisconsin's protection and advocacy agency for people with disabilities and mental illness. Mr. Hagopian's legal career has been devoted entirely to serving low-income and underrepresented populations. His areas of practice include community-based long-term care services and supports for people with disabilities, guardianship and protective placement, and prevention of abuse and neglect of people with disabilities. So please welcome Mitchell Hagopian.
Thanks, Joe. Thanks to the bar for putting on this important CLE and including this particular topic as part of it. As Joe indicated, I'm an attorney with Disability Rights Wisconsin, and just a little bit about us. We're the federally mandated protection and advocacy system for people with disabilities in Wisconsin. And among other things, we help protect the voting rights of people with disabilities pursuant to the Help America Vote Act. We do run a voter hotline for people with disabilities that's available anytime, but is particularly important. On election day, if people are experiencing problems with accessing their right to vote as a person with a disability, they can contact that hotline and they'll be able to talk to somebody and we'll attempt to problem solve that issue. And we also are part of the Wisconsin Disability Vote Coalition, which is a group of organizations dedicated to preserving and protecting the rights of people with disabilities to access the right to vote, to register to vote, and to vote. So a little bit about us. So what we're going to cover today is the right to vote for people who are alleged to be incompetent. We'll do a summary of the election and guardianship law, talk about a little bit about the potential conflict. I don't think it is actually a conflict between the election law and the guardianship law. How you can keep the right to vote in a guardianship case, and then also how you can restore the right to vote if you're a person who is already under guardianship and has lost that right. And finally, we'll talk a little bit about how you would develop and craft a case to actually either preserve that right or restore it in a later proceeding. So the basics of voter eligibility law in Wisconsin, you think you've heard all about that this morning, but basically you have to be a U.S. citizen, you have to be over age 18 on election day. You have to have resided at your current address in Wisconsin for 28 days before the election. If you're there less than 28 days, you vote where you used to live, assuming that was in Wisconsin. You can't be a felon or on paper, and you cannot have been determined by a court to be incompetent to vote. And of course, it's the last check mark there that is what is going to be the topic of today's discussion. So let's start with just a discussion about the Constitution and the right of suffrage that we're guaranteed by the Wisconsin Constitution. Basically, anybody in the state is eligible to vote as long as they're over age 18. Section 1 of the Wisconsin Constitution says, every United States citizen age 18 or older who is a resident of an election district in this state is a qualified elector of that district. So it's exceedingly broad definition of a voter. But then immediately after that, there is the exception for people who have been adjudicated incompetent. So, and that reads, you don't have the right to vote if you've been adjudged by a court to be incompetent or partially incompetent unless the judgment specifies that the person is capable of understanding the objective of the elective process or the judgment is set aside. And that was, that constitutional provision has basically been codified in Section 6 which is the chapter of the statutes that deals with elections, which you've probably heard a lot about already this morning. And particularly, it's section 6.03 of that chapter that is relevant to what we're going to be talking about today. And that same constitutional provision has basically been codified also in the guardianship statute, which is chapter 54 of the Wisconsin statutes. And we'll talk about how those two statutory provisions implementing this constitutional right and the exception to that right work together. So a basic summary of both the election and guardianship law is that, first of all, and here's the most important part, only a court can remove the right to vote of a person who has been alleged to be incompetent. Nobody else can interfere with that right to vote. So that means that, election officials can't do it, family members can't do it, friends can't do it, service providers can't do it, powers of attorney can't do it. Nobody can do it except a court. So remember that, because that's kind of the lodestar of this whole thing today. And the standard for removing the right to vote is whether or not someone is incapable of understanding the objective of the elective process. And finally, an individual who loses the right to vote through an incompetency finding to vote can petition the court to have their right to vote restored. So, as I said, section 6.06 sub 3 requires an adjudication of incompetency to vote pursuant to chapter 54 before an individual who's alleged to be incompetent can be denied that right to vote. And section 6.03 relates to disqualification of electors. And that section basically, it says, any person, the following persons shall not be allowed to vote in any election, and any attempt to vote shall be rejected. And it then goes on to say, any person who is incapable of understanding the objective of the elective process or who is under guardianship, unless the court has determined that the person is competent to exercise the right to vote. And then again, it's sort of repeated in sub 3 of that section. No person may be denied the right to vote or register to vote by reason that the person is alleged to be incapable of understanding the objective of the elective process unless the person has been adjudicated incompetent in this state. And then if a determination of incompetency of the person has already been made, or if a determination of limited incompetency has been made that does not include a specific finding that the subject is competent to exercise the right to vote, and a guardian has been appointed as a result of any such determination, then no determination of incapacity of understanding the objective of the elective process is required unless the guardianship is terminated or modified under section 54.64. And I think you heard a little bit about section 6.48 of this statute earlier today. That's a section that deals with challenges to voters for basically any other reason. And I just want to make it clear that section 6.48 applies to the other qualifications for voters, age, registration, residency, and all that kind of stuff. But 6.48 itself specifically excludes the people who are alleged to be incapable of understanding the objective of the elective process, excludes that group of people from that process and refers to the 6.03 process. So just to make that absolutely clear. Now, as I said, Chapter 54 is the guardianship statute, and when we codified the guardianship law back in 2006 or something like that, we in this state moved from a plenary guardianship system to a limited guardianship system, a presumption of limited guardianship. The idea being that a person who is under guardianship should only be required to lose the rights that they have specifically been adjudicated to be incapable of exercising. And so generally in the guardianship law, unless a right is taken away from you affirmatively by the court, meaning and that finding is supported by a specific finding of incapacity, that right is retained. And rights can't be removed by a general finding of incompetency in a plenary order. Now that isn't the way it used to be. Guardianship used to be codified under Chapter 880 of the statutes. And in Chapter 880, plenary guardianship orders were the norm. Basically, you were determined to be incompetent, you lost all your rights. The court had the discretion to retain rights for you, but they seldom did. In my experience over the years, the only right I regularly saw retained in the old Chapter 880 orders was the right to get a fishing license. Because in Wisconsin, you better be able to fish. If you can't do anything else, you need to be able to get a fishing license. But that was pretty much the only one. Every once in a while you'd see something else, but typically not the right to vote. So as I said, the rights can't be removed by a general finding of incompetency, and the statutory provisions for that are there. And within Chapter 54, there are actually two ways you can lose the right to vote, but both of them require judicial process and a judicial finding of incompetence to vote. The first one is a standalone petition to declare incompetence to vote. And under this procedure, anybody, any elector, can determine or decide that the person that they see in front of them is incapable of understanding the objective of the elective process. And if they want to act on that and keep that person from voting, they have to actually basically do a little guardianship action that is just about that right. So they have to file a standalone petition under 54.25 of the statutes that alleges that the person is incapable of understanding the objective of the elective process. And that triggers a little procedure, much like the one we're going to talk about in the restoration part of this talk. We're not going to talk much about that. I don't know. In my experience, I've never ever heard of anyone actually doing this. It would be quite a project because, as you'll find out, you got to appoint a guardian ad litem, you have to have a hearing, all sorts of things have to happen. And, I don't think anybody who I've talked to related to the voting process cannot remember this ever being used. So we're not going to spend any more time on it. The more likely place where this is going to become relevant is during the regular guardianship process, where someone files a petition for guardianship on a person who they believe to be incompetent for all sorts of different reasons. And as part of that adjudication of whether or not the person is a proper subject for guardianship, the issue of voting will be specifically discussed and adjudicated in the context of that proceeding. So basically, the people who have lost the right to vote because they're incapable of understanding the objective of the elective process. Boy, that's a mouthful, isn't it? And I keep saying it. But the people who have lost that right because of that finding are all basically under some form of guardianship. Either the Chapter 880 orders that predated the 2006 recodification, which may still be in effect. Once a guardianship is imposed, there's no actual required review of that guardianship. So there are a lot of people out there under guardianship under the old 880 orders. And then since 2006, the guardianship order would have a specific finding regarding incompetence to vote, and we'll talk a little bit about that in a minute. I did that one already, right? Okay. So harmonizing 6.03 and 54.25. There's a little bit, I read the 6.06 thing already. where it talks about, if you're under a guardianship, it says if a determination of incompetency of the person has already been made, or if a determination of limited incompetency has been made. So at 54.25 doesn't have general findings of incompetency anymore. So now, as I said, the guardianship orders consider each area of capacity separately. And if you look at a guardianship order, it's a 3-page document, and there's a whole series of rights that are affected by that order, one of which is the right to vote, but there's everything else too: the right to serve on a jury, the right to execute a will, the right to make medical decisions for yourself, the right to interact with other people. All those things are in the guardianship order. And the way that our state handles this in the orders is through checkboxes. The checkboxes indicate that the court has actually made a specific finding with respect to that particular area of capacity. And in Wisconsin, if the box isn't checked, you didn't lose the right. So the only rights that are lost through a guardianship are rights that have been checked as lost or limited by the guardianship order itself. And voting, unlike many of the rights in a guardianship action or affected by a guardianship order, is one that the ward either retains or they lose. Other things within the guardianship order, the ward may lose the right, but then the guardian can exercise it on their behalf. So, access to medical records, making medical decisions, all that kind of stuff. The authority gets transferred and delegated to the guardian. That's not the case with the right to vote. If the person doesn't understand the purpose of the elective process, the court decides that. They check the box that says you've lost the right to vote. That person's lost the right to vote, and nobody can exercise it on their behalf. So if you're looking at Chapter 6, at 6.03 and 54.25, the law, the election law requires that there be a finding of incompetency. And every single modern guardianship order has a specific finding of incompetency with respect to the right to vote. Because if you look at the order, it's either there's a box, and if it's checked, the court has made a determination that you lost the right to vote. If it's not checked, the court made a determination that you have not lost the right to vote. There isn't a box that says you keep the right to vote. That's not the way we do it in guardianship. You have to affirmatively lose it, and if you didn't lose it, it's there. So, but each modern guardianship order will have a specific judicial finding related to incompetency or incapacity to vote. Okay. So let's get to the issue of first how you might lose it in the initial guardianship action and what you might want to do to prevent that from happening. Because, of course, you never have to bother with restoring it if you never lost it in the first place. And that's always the best thing to have happen for people. And there's a lot of ways to avoid that finding. First of all is to not get involved in guardianship at all if you don't really need it. There's a lot of disadvantages to being a person under guardianship and also for being a guardian of such a person. There's a lot of reporting requirements. There's different obligations that you have to undertake. It can be a pain for the guardian, and it can be very bad for the ward, especially those old 880 orders where there was no possibility to limit the guardian's authority over the person. So at Disability Rights Wisconsin, we've long advocated for people to use alternatives to guardianship in order to deal with, incapacity issues. If there are other means less restrictive than guardianship that can be used to address those incapacities, they should be used. And In Wisconsin, we, within the past 5 years or so, created the supported decision-making law, which allows people to designate supporters to help them make decisions. And there's all sorts of things to do in terms of, people who can't handle their own money. You won't necessarily need a guardian of the estate if you can set up a representative payee or a protective payee to handle those financial decisions. And then for medical decisions, the other area that becomes important for people with disabilities and elderly people who are losing capacity and also becoming more frail, and that is healthcare powers of attorney. If you have a duly executed healthcare power of attorney that allows your agent to admit you to a nursing home or a larger community-based facility, and also authorizes that person to make decisions regarding life-sustaining medical treatment, between that and the general authority associated with it, there's pretty much takes care of all the medical decisions. So there's a lot of ways you can set up alternative means that serve the same purpose as guardianship, but in a far less restrictive way. And as a side benefit to that, if you set up those things and that's the way you deal with incapacity, you don't lose the right to vote because you haven't had a court determination that says you're incapable of understanding the process. So that's where we start from. Let's try to get out of the guardianship system altogether, but that doesn't always work. For some people, guardianship is really the only way to deal with protecting them from abuse and neglect, which is what the real purpose of the guardianship system is. But don't be afraid. You still don't have to lose it just because you're in the guardianship system. You can retain the right to vote. As I said, there's going to be there's going to be a hearing. There's a lot of pre-hearing work that's done in a guardianship action, as you may know. And there are many opportunities in this process to make sure that a person who shouldn't lose the right to vote doesn't lose the right to vote. And so the first thing is, to start a guardianship action, you have to file a petition. Well, the petition itself, you can identify on the petition which rights you think the person is incapable of exercising. And so, first thing, if you think the person who you're trying to protect probably has the capacity to vote, don't check the box that says take it away. That's the first thing. That's not dispositive or mandated on the court to follow that, but it's a step in the right direction. If you didn't ask for it to be taken away in the first place, there's probably a better chance that it won't be taken away. But even if you didn't check the box, a guardian ad litem is appointed for this process, and the first thing you ought to be doing, either if you're the ward and you want to keep it, or you're someone who's the petitioner who wants the ward to keep it, or someone else involved in the process who wants to keep it, a friend, family member, whatever, then talk to the GAL and say, hey, make sure when you're going through all this stuff, you don't forget about the right to vote, and that there is this legal standard for that you need to consider. And by the way, I think the ward here meets that capacity standard. The same thing, as part of any guardianship petition, there's going to be a medical or psychological examination done of that person so there's a medical opinion regarding the various areas of competency that are considered under a guardianship order. So talking to that examining physician is also important, because one of the things they render an opinion on is whether or not the person has the capacity to vote. So in our experience, this is not something that doctors particularly think about. They just kind of, what do they know about voting? No more than the rest of us. It's not like something you learn in medical school. So what we found is that in guardianship actions, there's a lot of reasons people file for guardianship on people. Typically, they're to deal with some emergency or perceived, impending emergency. So, I would guess about 80% of the guardianships are filed either on people turning 18 who have intellectual disabilities, and their parents are very concerned that they are going to lose any ability to impact decisions related to their child once a person turns 18. And, we're doing a lot to try to dispel that notion that there's a lot of less restrictive things you can do. But nonetheless, that's a big group of the people who are under guardianship. That's how it happens. And so what they're concerned about their 18-year-old getting solicited by a credit card company to open up their, American Express account and then bankrupt themselves. They're worried about, somebody taking advantage of their, naivete or whatever it is, and getting them in some trouble with the law or with other people. These realistic issues to be concerned about. About the last thing they're thinking about is whether or not this person should be voting. And so, and then the other people who are affected by this are the very elderly people who are losing capacity as the result of dementia or frailties of aging and that sort of thing. And again, those are typically guardianships that there's a reason people are filing for them. It's because something bad has happened or is about to happen to some elderly person. And again, the things that people are focusing on have nothing to do with the right to vote or to serve on a jury or make a will or any of that stuff. So a lot of these kind of, I would call them peripheral things that are related and included in the guardianship system don't get thought about at this time. So the key is to raise the awareness of the people who are going to ultimately have an influence on what the judge rules in this thing. And so that's the GAL, and that's the doc who's doing the competency evaluation. Those are the people who, if you convince them that, you can take away all the other rights, but make sure you leave the right to vote because here's why and all that. We'll talk about that shortly. And like I said, the physician's report has a box to check about whether or not they recommend taking away the right to vote, and so does the GAL report. So, those forms indicate that somebody thought about it, but whether they did or not is another question. So yeah, I guess I'm ahead of myself a little bit. That happens, But the first thing to do, if we move on to restoring the right to vote. So let's say that none of the aforementioned things either didn't happen, or you weren't successful and the court took the right to vote away. So then we move to restoring the right to vote. But let's backtrack a little bit. Let's first figure out, well, did you lose the right to vote? Because, like I said, the order is the court document which says whether or not the right to vote has been taken away. And check it, because it might not have been. You never know. There are some, courts who, as a routine matter, don't take the right to vote away from wards unless, there's some specific reason to do it. I think kind of the assumption being they're probably not going to exercise it if they don't know anything about it anyway, so who cares? But and I think some physicians may not check the box for that same reason. It just doesn't seem like a very important thing at the moment when they're doing it. So check. I mean, you want to restore the right to vote? Well, check to make sure you lost it in the first place, and check it at the original order. And one thing, when a guardian is appointed, they're issued letters of guardianship, which are the proof that you have the authority to act on in the areas that have been delegated to you. And because, as I said at the beginning, the right to vote is not one that can be delegated to the guardian, it's not referenced in the letters of guardianship. So you can't just look at those. You can for almost everything else and see, what rights the person lost, because they've lost and they've been delegated to the guardian. But the right to vote is not one of them. It's not addressed at all in the letters of guardianship. So that won't help you. You do need to check the original order. And again, like I said, the older orders, the Chapter 880 orders, almost certainly the person lost it, but you should check it anyway. And, there are going to be a lot of people, my work is primarily with people with intellectual disabilities. And, their guardianships, many of them were imposed at age 18. So there's a whole bunch of people out there who are, alive and well and doing fine, who were put under guardianship well before 2006, who are still, well within the age when they would be, potentially able to learn things or regain, or if they never lost competency to do something like vote. The Chapter 880 folks are the ones who are very much likely to be affected by these, and also a group of people who might have lost the right to vote at a time when it wasn't really an important consideration in the actual guardianship action. So in order to restore the right to vote, the procedure is found at 54.64 sub 2, which is the part of the statute which deals with termination or modification of the original order. So you have to file a petition to modify the guardianship order in order to get the right to vote back. There are not many restrictions on these motions. They generally have to be filed more than 180 days after the last hearing on guardianship has been heard. So 6 months. It's not like a jurisdictional thing. What it is if you file a petition before 180 days have passed since the last time somebody looked at this, the court has the discretion to either allow a hearing or not. If you file it 181 days afterwards, you automatically get another hearing. But even if you file it before the 180 days are up, if there are exigent circumstances, like an election is imminent, the judge, can and is more likely to grant another hearing on this particular thing. And how could that happen? Well, you have one of these 18-year-olds who is, turns 18 and mom and dad are, petrified about what's going to happen when they reach age 18. They file and obtain a guardianship over their adult son in June of, 2022. Nobody's thinking about voting. None of the, things we talked about happened in the petition. And then come to find out that, the young man actually is all sorts of interested in voting and elections and politics and all. And there are a lot of people who are in that boat. But the right got taken away, maybe without anyone really thinking about it. So the person has expressed an interest in voting before, in the midterms, 2022 midterms. That's less than 180 days from when the guardianship order was imposed. It would be appropriate for the court to have a hearing on this particular right, assuming they agree that it was not one that was, contemplated with the full gravity that it should have been the first time. So there is a form on the court website to modify a guardianship. It's GN 3655. Don't use it if this is all you want to do. That form is used to modify any part of the underlying order. It's about 3 pages long, and when you fill it out, you indicate the rights that you want to be reconsidered in this particular action. So you'd check one box, and the rest of the thing would be blank. All these pages, it's cumbersome. So what we have done to make this easy for everybody, we've created our own little forms, 2 petitions that are specific to the right to the vote, and then a draft order that can be used in the event that the court decides to restore the right to vote. And these are at the tag end of my outline, but they're also available at the website that's on this slide, and they're quite simple. The person's over 18, they believe they're competent to vote, et cetera, et cetera. The 4 basic things necessary to get the petition in front of the court. And we have 2 versions of the petition. One is if someone is filing it on behalf of another person, so a friend or family member or their attorney is filing it. And the other one is if the person is filing it on their own. So one for the ward, one for someone else filing on their behalf. Once you get into the process of trying to restore the right to vote, then the court, the procedure that's followed is sort of like dictated by the court. And so they determine who's going to get notice of this hearing. They appoint the guardian ad litem, and one is required to be appointed in these proceedings. And then they set the hearing date. It's pretty simple. Now, one of the issues that comes up, or may come up in your case, is whether or not another competency exam is required in order to restore the right to vote. So, if you look at 54.64, which is a statute which governs this procedure, it does not require that a new competency evaluation be done as part of that. There is a requirement in the original petition. It says you got to have a competency evaluation, but not to modify or terminate the guardianship. So it's not required. So let's start from that. It doesn't, but I'll tell you that courts are in the business of listening to doctors and psychologists when it comes to competency things. So the default sort of position is whenever anybody is challenging anything related to competency in a guardianship, the default, judicial position is usually going to be, well, let's get a psychologist to evaluate this person again and see if they know how to do this. And that may be appropriate for a lot of the areas that are subject to guardianship, the decision-making areas. But it's not really appropriate for this proceeding. And that's because medical people, like I said, they don't have any special expertise in knowing what the purpose of the elective process is. That's not something they learned in medical school. And the people who are involved in this proceeding, the guardian ad litem and the judge, they actually have a little bit more expertise in the elective process typically. They've been to law school. And so they understand, these kind of concepts and are in a better position really than a doctor to opine on whether or not the person understands this process. And the other reason you don't want to have this is because psychological examinations are expensive and they're time consuming. And it seems a shame to, make someone go to a psychologist, get evaluated all over again, spend a couple $1,000s just for that person to render an opinion, which essentially a layperson could determine through other means, more easily and more quickly. And the quickly part is important too. When do people start thinking about this? About 2 months before the election. And typically it takes a lot longer than that to get a competency evaluation completed. So we highly advocate that, it's unnecessary in this proceeding. If the court, but it's a discretionary call on the part of the court. If they decide that a competency evaluation is appropriate, then they can order it. And if that happens, then you do what we talked about earlier, which is you go in and you advocate on behalf of your person, or the ward goes in on behalf of themselves and argues to the guardian ad litem and to the judge, or I'm sorry, the medical examiner, why they should find that your capacity to vote is intact. So let's spend a little time on the legal standard for restoring the right to vote, the competency standard. And this is important because there's really a separate little competency standard for the right to vote. It's different from the regular incapacity standard that is used to determine competency to exercise other rights that are subject to the guardianship. So, as I've said ad nauseum now, the standard is incapable of understanding the objective of the elective process. And compare that to what the regular competency standard is, which is the individual is unable to effectively to receive and evaluate information or to make or communicate decisions to such an extent that the individual is unable to meet the essential requirements for his or her physical health and safety. That's a way different standard than whether or not you understand the elective process. First of all, it doesn't involve your physical health or safety at all, as far as I know. So, the main reason that you can lose the right to do anything is if it affects your health and your safety. So this isn't it. So let's explore that just a little bit, what it means. So this phrase, understanding the objective of the elective process. First of all, it's not defined anywhere. It's not in Chapter 6 of the election law statute. It's not in Chapter 54. It's nowhere. There's, as far as we can tell, there are no published cases that address what this means. But so we're looking at ourselves. We're the only ones who've been thinking about this, as far as I can tell, with any depth of inquiry. So there's a couple things to way to look at this, and I've litigated one of these cases, which makes me an expert. And when we did it, we just took it. Well, what do you think about? What is an election about? What is the elective process about? And think about guardianship. You're not supposed to lose or be held to a higher threshold of capacity than anybody else who's exercising the same right. So what's the capacity, for a regular voter? Okay. It ain't high, right, people? Okay. You don't have to have a deep understanding of, the Constitution or the Electoral College or, the role of political parties in American, jurisprudence or any of that stuff. You just, oh, I like that guy, so I'm going to vote for him. And that's the threshold that basically should be applied to anybody who is, attempting to get their right to vote restored. This is sort of so what we came up with out of this is we looked at the dictionary, which is where you usually look when you're trying to define, terms or phrases in the statutes that aren't specifically defined in the statute. So, there's three big words here in this thing. First is objective, and that means something towards which effort is directed, an aim, goal, or end of action. Elective means relating to an election, and process means a series of actions or operations conducing to an end. So what it means is to understand the purpose of an election. Ergo, the ultimate objective of the process is to vote for the candidate that the voter wants to win. I like Joe. That's pretty much it. If that person can express that I want the guy or the woman or the other person to win, that's pretty much they understand the purpose of the elective process. It ain't rocket science. That's kind of the bottom line. But if you're in a case you're representing someone and your client, actually knows a lot more about it than just that, it does not hurt to make that evidence known to the court. So, as you're litigating one of these cases, you'd certainly want to probe this with your client. Whether or not you want them to then testify about it is another question. But, why do you want to vote? What's important to you? Do you understand that, oh yeah, I get it. I want to vote because these are the people who make decisions for me. And, I'm a person with disabilities and I rely on Social Security and SSI and Medicare. And these people are making really important decisions that are going to affect my benefits. So yeah, that's a pretty deep understanding of why that's important. Why do we have elections? Well, to pick the people to run the country. How do people vote? Well, they go to places or they vote absentee. If the person understands all these kind of things, those are all evidence that they understand the elective process at least as well, maybe better than people who have not lost the right to vote. If they can explain, what offices they're interested in voting for, that's relevant information. And then if they have had experiences with voting in the past, so, they're 18. Yeah, I voted in every single student council election that I could because I wanted, my friend Joe to win. So, as you do this, the guardian ad litem is going to be a super important person in this process if you're in court on this. But if you have witnesses who can testify to the person's capacity to understand the elective process, bring those people along. Ex-teachers, former teachers can help with this process. Friends who have had discussions or family members with the person about elections and, maybe you've talked about together with him, complained about the commercials you see in the middle of the Packer game. And these are all things related to the elective process, and they're all important for the judge and the guardian ad litem to understand. So, the other thing is, if the guardian ad litem and the petitioner all agree that the person's right to vote should be restored, you can also ask under 5464 to have the court on its own motion restore that right to vote. So consider doing that. That way avoids the hearing. And one thing I'll say about your client in these matters is, we're lawyers. We go to hearings all the time. Clients don't, as you well know. And people with disabilities can be really intimidated by court proceedings. And so even if you have this nice, detailed, long, eloquent conversation with your client about, what it means to vote and why you're interested in getting it back, they might freeze up at the hearing. And in fact, that sort of happened in the case I did. But because we had prepared the client and he had spoken with the guardian ad litem at length, and the guardian too was in support of this, those people were able to testify about what their conversations were with that person beforehand. And even though when the judge started asking my guy questions, his answers were a little fuzzy, the court determined that, based on what he had talked to with the guardian ad litem and the guardian and what they had testified to, that he was comfortable that this person understood their right to vote. So, again, it's not a complicated process. It's about the simplest legal process you could do. It's a discrete issue. So we hope that attorneys will do this. If the right to vote is restored as part of this proceeding, you can either use the court order based on the modification petition, but again, that's one that's got a bunch of stuff that's irrelevant, or you can use the order that we have drafted that's at the end of the materials. And then the Register and Probate will prepare a document called a GN 3180, which gets sent to the Wisconsin Election Commission, and that updates the statewide voter registration database. Now, I would recommend that if you do get an order that restores your right to vote, just to be on the safe side, I'd get a certified copy of it and I'd tuck it in the pocket of the voter. So when they go to vote, if the registration list hasn't been updated, they can register if they have to and vote then. So here's a couple of resources. Like I talked about earlier, the DRW voter hotline. We run this and we're available, not 24 hours a day, except maybe on election day, to answer questions people have about this. And then the Wisconsin Guardianship Support Center. If you don't know about this resource, you should. It's really a great thing that's pretty much unique to Wisconsin, which is a publicly funded support center for all things related to guardianship and alternatives to guardianship. It's staffed by an attorney who, knows the guardianship and protective placement and power of attorney statutes inside and out, and can, provide unbiased advice to anybody who has a question about it. They don't represent clients, they just answer questions. And they know a lot about the voting process too. So with that, I believe I'm finished. Thank you.